Good morning, sir. Mr. Odekirk?
Yes, thank you. May it please the Court, my name is John Outerkirk, and I represent the appellant mother. With the Court's indulgence, I would like to begin by suggesting that these kind of issues, removal issues and custody modification issues, need to be looked at not only in their own light, but from the perspective of the question which they present. A removal case really presents the fundamental question, can we maintain the status quo of the allocation of parental time? Whereas a custody modification is really asking the question, should we or should we not change the allocation of parental time? And the reason that that distinction, I believe, is important is because a number of the factors that we concentrate on when we talk about removal cases and change of custody cases, real advantage and best interests, in some ways address specifically the instances where the question, can we maintain the status quo, is answered in a series of no's. In the cases where those questions are answered in a series of yeses, the issue sort of folds itself into the standard, and so the standard itself becomes less critical. And
now in this case, both the mother and the father had legal and physical custody shared.
Yes, you are. That is correct.
Would the custody impact on the answer to any of the questions if the mother had full legal custody or full physical custody? Would that change the answer at all?
I would argue that it would not, and for the following reason. If we start with the basic question, can we maintain the status quo? And the answer to that question is yes, the move can happen and we can. Then really the analysis at that point is over.
But how can that be on the facts?
No, you're saying hypothetically.
I'm saying hypothetically.
Hypothetically. So you look at the case, if somebody's entered into an agreement that says you will all stay within 10 miles, and somebody wants, in Massachusetts, and somebody wants to go, not this case, somebody wants to go 15 miles, and it's outside Massachusetts, but is perfectly willing to leave the child back in the Massachusetts school in a custody arrangement, then you're saying it's not an issue, correct? So
I'm saying that would resolve, the facts in that hypothetical would resolve itself to allowing the removal.
Yes.
It was interesting to note, and I add as a footnote that for some reason the trial judge didn't put this in with her discussion of the New Jersey law that she relied on. In the New Jersey hierarchy, there is another question that follows, can we maintain the status quo? And that is, can we minimize any changes to the status quo by parental accommodation? That wasn't an issue in this case because the judge didn't make that part of her analysis. Where we get to the thorny question is, can we maintain the status quo? And the answer is no, we cannot. And then we have to look at two questions which are incorporated in real advantage and best interest. To what degree will we modify parental status quo, and does that modification require denial of the removal or not? But in all of that analysis, it doesn't matter what the starting point was for the parties. That analysis would be the same if it was a sole custody case or a shared custody case. And the same would be true in a change of custody case. The question is, shall we or shall we not change?
And you agree that this will result here in a modification of custody?
No, I'm arguing that the modification of custody was not in any way, shape, or form necessary to resolve this particular dispute.
No, I'm saying that on the facts here, won't there in effect be a modification in the custody?
Only in a very limited circumstance, and that limited circumstance would be that if the parent who wanted to move was ordered to remain, or ordered not to take the children out of the state, and then chose to leave anyway, not taking the children, that would create a need to modify the order of custody. But if the order was for the parent not to take the children out of state, and the parent then elects to remain in the state There's no need to change the custody.
But you're saying on the facts of this case, if in fact your client is not ordered to keep the child in Massachusetts and moves to Burlington, is it?
Bristol.
Bristol.
I'm sorry, Bristol.
Where do the children go to school?
The plan that was proposed at the trial was that they would go to, it's a regional school district, and I believe it was the Newfound School District,
And what
but
is
in
the-
Bristol, New Hampshire.
And how far is that from the father?
Well, there were differing estimates at trial, but
Seen in the light most favorable to the father.
seen in the light most favorable to the father, about 30 to 40 miles away from where he worked at Loon Mountain Ski Resort.
But that's not where he worked there on weekends,
Correct.
and his normal employment was in Massachusetts somewhere.
He had,
How far from his home?
I cannot say with certainty, but I would guess from having made that trip, it's probably 80 miles.
Let me say it this way. You said it need not necessarily impact. They have joint custody. Am I correct in understanding that these children spend certain nights of the week with their father and certain nights of the week with their mother?
No. The schedule as it existed at the time of trial was the
Right.
result of further modification that was done on June 29th in 1999.
Right.
And that agreement had every other weekend with the father, from Friday afternoon until Tuesday morning when he took them to school.
Well, and who took
And
them to
alternate weeks.
Yeah,
One
but
week he did not have a weekend.
He's taking them to school on Monday mornings and Tuesday mornings. Correct?
That's correct.
Okay. So now you're saying you're asking these children to be driven 80 miles on Monday morning and Tuesday morning to school.
No, that was not what the mother was asking. The mother was asking that the court adopt the guardian ad litem's revised visitation or schedule, parenting schedule, which changed the duration of the weekend visits so that the children were back in school, back in Bristol by Sunday, but changed the midweek visitation so that when all was said and done, the days were switched around a little bit, but the guardian ad litem's proposal really afforded the father one less day of visitation,
So
or of parenting
So
time.
there is a change in the custody situation, and not only that, but there was a stipulation, wasn't there, or am I not correct? That was incorporated in the divorce decree that the parties would live within a 25-mile radius of Chelmsford, and that they agreed to send their children to school in Chelmsford.
Well, therein lies part of the rub. The partial permanent settlement said that within, I think it was 25 days of the divorce, they would move to Chelmsford from their respective homes in New Hampshire. There was nothing in the agreement that said they agreed to live in Chelmsford. That somehow got into the colloquy and the discussion, but the actual wording of the agreement was that they would move there. That would be their home base.
Mr. Odekirk, let me ask you this. It seems to me that this is a very difficult situation, and I understand that. And I think, there are two loving parents here. They happen to be divorced. Their lives are complicated, as are the lives of many families in the United States. But it seems to me the following. People in good faith negotiate for the best arrangements for their children. Sometimes they do it by agreement, sometimes they need the assistance of the court when you've got a dissolved marriage, correct? And you enter into certain kinds of understandings. And then the respective parents' lives move on, or indeed sometimes the children's lives move on. They need special attention, they need special kinds of education. Both of these parents have got legitimate conflicts in their life. But if they can't resolve it between themselves, or now there are four parents, two biological parents and two step-parents, what is the court to do? And why doesn't it make sense to say, if you can't resolve it among yourselves, I'm going to simply uphold the original agreement? Because there is no fairness here. there's a new marriage, there's another child with the second father, and somebody isn't going to be able to have their biological parent close at hand. Why would you ask courts to make quite difficult and, in some respects, rather arbitrary decisions, rather than saying, this is what you agreed to, and as you progressed with your life, you knew that that's what you agreed to?
Well, my initial response to Your Honor is probably not on the record in this case, but one would hope that the court is always the last resort
Of course.
of making
But
these kind of determinations. But
as I looked at the judges, you know, and you may differ, and I understand you may differ with some of the factual findings, and you may say, why do you look to New Jersey? Well, because, you know, when there's no clear law from the court of last resort of the appropriate jurisdiction, you look to see how other people have approached it. But if you take away the nomenclatures as to what the standard is, essentially it seemed to me that what the trial judge was doing here was saying that they're valid competing interests. They had an agreement. The children are in that school. They're doing well in that school. To disrupt all of these arrangements, where I'm not sure, she says, that this is going to be better for everybody. Somebody's going to get hurt. I mean, you know, I looked at the proposed alternative arrangements. One could say that a parent taking a child to school is a terribly important part of child rearing.
And getting their homework done the night before you take them to
I mean,
school
the
is
whole
a
relationship.
critical part.
So to come in and say, well, actually, the number of days is the same, only, you know, the child won't have to commute. And again, I'm not suggesting that your client, or even the father in this case, was proceeding in bad faith. It's just, it's an on-the-ground reality. And I think if there's a certain kind of stability, what's wrong with that solution?
if I can answer the questions in the order as I recall them. I think in response to your question about what's the unfairness about enforcing the original agreement.
No, not what's the unfairness, but why isn't that, given that there's going to be unfairness in light of changed circumstances? By the way, it won't always be choice. Somebody's company may move the person out of state, and that person can't find another job. So this isn't always choice. This is just on-the-ground, hard reality.
My response to that is that I don't think that there's a problem with enforcing the original agreement. In this case, the problem was the interpretation of the original agreement. The original agreement, specifically in the third paragraph of that subsection, made an allowance for exactly what Your Honor was suggesting, that people's lives move on and that children's lives move on, and it set out a procedure by which if somebody wanted to go beyond that 25-mile radius, this is how you do it. So I think that agreement acknowledged and recognized exactly that point.
No, it gave only a notice provision with time to resolve the problem that would thereby be created. And I think the father's argument is right. That resolution in that context can mean, if necessary, court involvement because the parties can't agree.
Well, of course, that's where we disagree with
I mean,
the trial court.
Otherwise, the notice provision would be kind of meaningless. It wouldn't accomplish anything.
Well, your interpretation is that the notice provision assumed that it was permissible to move.
I would make several assumptions. The first is that the notice provision made it permissible to move. My second,
Anywhere?
I would say yes. I think my second assumption, and I'm not, again, we have differing versions of the facts, and the judge made a call for one version over another. But it would seem to me that that agreement was written from an expectation that there would be the same level of cooperative settlement discussion that went into the original agreement. And as Your Honor indicated, people's lives moved on, and when we get to this point in time, that level of cooperative settlement agreement didn't exist anymore. And I submit that would be my proposal to the court for how it ended up being a court case rather than being a mediation case
Of
or
course,
being a
and
settlement case.
as a general matter, courts try to intervene in the private lives of families as little as possible, and everybody understands that when you finally come to court, you are asking the judge to resolve it. The judge does his or her best to interpret what the parties intended. That's a very good starting point. But once she's done that, if the impact of, in this case, a physical move of one parent is to have a substantial impact on the existing arrangements with the other, and the parties are unable to enter into an agreement, why is it inappropriate for the court to essentially go back to the base understanding?
Well, I think that particular answer is grounded in the particular nature of the removal statute, and that is that in the removal arena, there is a certain lack of self-determination. Once, and we obviously can argue back and forth on whose fault it was that more than the 5 years went by.
We are not talking about
but once
fault.
that 5 year went by, she had to. It wasn't a matter of I'd like to work it out and come up with something else.
No, she had to move, and that's what I'm saying.
No, she had to go to court.
I mean, she had to go to court, yes. But
So
she
she
might
didn't-
also have had to have moved. I mean, she could, for example, have been transferred, and it happens all of the time, to California if she were working full-time.
And under this set of circumstances, again, she would have had to petition the court, even if the reason for the move.
I see that your time is up, but even if you don't view it as enforcing the original agreement, how did the judge make an error when she said basically if the result of a removal where there is shared physical and legal custody is going to result in what she analyzed as a significant disruption of the joint custody arrangement, why shouldn't she take the position, as I believe she did, that needs to pass muster under the standards for a modification of custody? I mean, that seems to me a perfectly logical approach. If it's going to have that effect, the mere fact that it has come before her under the rubric of the removal statute, if the effect is going to be a modification of custody, it seems perfectly appropriate to me that she look at it as a modification and say, is there a change of circumstances? She found, yes, there was. But was this modification in the best interest of the children? And she found no.
My response to that, and yes, I know my time is up, is that she didn't do that. She didn't say, I'm looking at this question as a removal question, and I'm looking at this question as a custody question. What she said is, I'm looking at this question as a modification, as a removal question. I will now employ this law that I have created. I will transform that removal question into a custody question, and then I will decide the custody question on custody criteria, even though it didn't come in as a custody question. It came in as a removal question, which should have been determined under removal criteria. And Rosenthal says you can't bounce back and forth between the two. You pick one and go with that one, but you can't piggyback one on the other. And what the judge in this case did was try and come up with a reasoning to circumvent Rosenthal to be able to piggyback and then do so.
Thank you, Mr. Odeker.
Thank you very much.
Mr. Wu?
Good morning, Your Honor. May it please the Court, my name is Adam Rowe, and I represent the father and the appellee in this case. And this is a case about joint custody. It's a case about a mother's attempt to effectuate a de facto modification of that custody.
Mr. Rowe, let me say this. The briefs were very helpful, but and of course you represent a particular client, and I understand you will advocate most forcefully for that client, but we actually have to set some ground rules because this is not an unusual set of circumstances. And so it's not helpful to me to say the mother attempted to effectuate a change, because quite often it is out of the parent's control to a significant degree. And help me think through the following circumstances. The mother is transferred to California. She tries her best to persuade her employer she has significant financial interests in the company because she's got, tenure and she's got pension things that's unripened, which if she loses will have a huge negative impact. I don't think you would say she's trying to effectuate a change in custody. And so the question is, what's the rule when you're faced with very hard choices?
And, Your Honor, in response to that, the rule is very simple, and it's one that's mandated by the legislature. And what the legislature has indicated in General Law, Chapter 208, Section 28,
Right. Yeah.
is that there must be, first, a material and substantial change in circumstances, and second, that the proposed modification must be in the children's best interests. And in this particular case, what the court looked at was whether or not this proposed move that the mother had to take the children from their present custodial relationship, and bear in mind that both parents had filed complaints which included clauses seeking sole physical custody in this action. The court employed the modification standard and made the determination that this particular move was not in the children's best.
No, I understand that. So I mean, to some extent, though, what's implicit in this order is that the mother in this case is able to stay in Chelmsford. And I'm asking you to help me think through a situation where it is not possible. In other words, there's a modification, and let's say, and again, proceeding on good faith, the solution is either take my California example, the father now has to assume full custody of the children, which the father may not be in a position to do. The father may have cobbled together a very difficult work arrangement in order to have, to be a single parent is not that easy. And so all of a sudden the court is confronted with, so what do? You can't say to the mother, you must stay in Massachusetts.
No, and that's exactly why we have the modification statute, General Law 28, or General Law 208, Section 28. And that's the basis of the analysis. The court ought to look as to whether or not the forced move of a mother out of state would constitute a material change in circumstances. I would submit most likely under that scenario that Your Honor proffers that it would. And then the question would then become whether or not the move, the custodial change of the children either going with the mother or staying with the father.
But in those circumstances,
It's in the best interest.
Right. But then what you take into account, though, is you don't say, well, you keep the mother in Massachusetts. Then you're looking at whether or not the father gets full custody or the mother gets full custody.
That would under that scenario, Your Honor, that would be correct. If there's no possibility of the mother remaining in the state, then by necessity, one parent would become the custodial parent.
I mean, was there a discussion in this case about whether or not the father could assume sole physical custody? In other words, if the mother has to move to Bristol, and the judge concludes that the change in legal relationships is such that it's not in the child's best interest to do this 80-mile commute. Was there a thought of leaving the children in the Chelmsford school and having the father have sole physical custody?
There was a discussion of that, Your Honor. In fact, the father indicated, and it's indicated in the GAL report as well, that he offered to move back to Chelmsford and stay there. The child's therapist testified at trial that joint custody in this particular case was appropriate and that neither parent should be awarded sole physical custody, that it was not in the children's best interest.
You understand that my questions are going to an underlying question, which is the order that the mother must remain in Chelmsford.
And Your Honor, in this case, the order is not that the mother must remain in Chelmsford. It's that it's in the children's best interest to maintain their presence there. And in this case, the mother testified that she would move to northern New Hampshire if and only if she were allowed to take the children with them. So it was a conditional situation.
So she was saying she was prepared to stay in Chelmsford.
That's correct, Your Honor. So this is not a fact pattern in which there would result in one parent, the necessity for one parent to be the sole custodian, since in this case, the status quo of joint custody could be maintained, and as the trial court opined, should be maintained in their best interests. And there was no need for a modification in which either parent would be awarded sole legal or sole physical custody.
Is it true then that Rosenthal is right? You will only apply either the modification analysis or you will only apply the removal analysis depending upon what the fact pattern is?
That is not correct, Your Honor. The Rosenthal, and this is the real advantage test that stems from the original decisions from out of state that has made its way from Hale and Giannis to Massachusetts and from Giannis down into Rosenthal. And what the real advantage test essentially is a method of analyzing what is in the children's best interests. So, and I'll say it again because I think this is an important point, that Giannis stands for the proposition that when a sole custodian desires to move out of state with a child, that in so doing, the proposed move must be based in good faith, but it must also be in the best interests of the children. And it develops a protocol in which it takes a Gestalt perspective and looks at all the factors, the intertwined relationship between the child and the custodial parents. Now, in joint legal custody situations, there are two custodial parents. There are two family units. And the child's best interests are intertwined with both.
Well, you can often have joint custody and separate physical custody. And so, so that what's unusual here, not unusual, but I mean, what is part of this case is that there was joint physical custody with really a switching backwards and forwards on a very, very frequent basis for these children.
That's correct, Your Honor. So in the joint physical setting, which is the key rather than the joint legal, and the issue becomes what's in the children's best interest. And in Giannis protocol, you take into account various factors, and that deals with
but you also take into account, obviously, the best interest requires that the custodial parent be taken into account as well.
Absolutely, and it takes into account the interests of the custodial parent and the interests of the non-custodial parent. In the joint physical custody situation, I would suggest that the court employ the same best interest test that's articulated in General Law, Chapter 208, Section 28, in that the court should look to all the factors, the interests of the custodial father, the interests of the mother, and the interests, ultimately, of what's in the best interests of the children.
Mr. Lowe, let me ask you this, and I understand that this is our jurisprudence, and we've laid it out in Giannis, but from the point of view of the state interfering with familial relationships, assuming that the parties can't agree when somebody wishes to move, what is the jurisprudential basis for a court to determine whether my reason for wanting to move, I'm a custodial parent, or let's say you take your client, the father wants to move, and why should it make any difference other than if it's some injurious reason to get back at the wife, to try and deprive, that I understand. But what difference should it make whether it's because the father wants to become a surfer, and that's been his lifelong passion, and he's worked hard, and he can now retire and become a surfer, or because his business takes him there, or because he remarries and his new spouse happens to be resident. I mean, what's the purpose served by looking at the motive of that parent?
The motive would be secondary, Your Honor. What the ultimate issue is what is in the children's best interest. The question should be looked at from the children's eyes.
I can understand if you look at whether the presence or absence of a motive to deprive the custodial parent. That I understand. In other words, the court is not going to tolerate that in effect what's happening is that the parents are continuing to be at war and are trying to use strategies to get even at each other. But it's the first part of that, the soundness for the reason for moving.
And by way of example, to answer, Your Honor, I would draw back to this particular case and look at what the court did in this particular instance. And what it did is it evaluated the mother's proposed reasons for her move. And one of the proposed reasons, for example, was the economic advantage that she indicated that she would receive if she were able to move to Bristol.
What difference does that make?
Well, it's a question of saying, is there an advantage to the mother's, is there a basis from the best interest of the child's standpoint? Does this proposed move give them some benefit? And if it benefits the mother,
But it seemed to me that's not what, it seemed to me that the jurisprudence has developed slightly along the line that says, first I'm going to look to see if this is a good reason to move.
Well, that is a good, I mean, it seems to me one would be, you don't want to have the court having to make the complex determination about what's in the best interests if the proposed move is itself, you know, not being proposed sincerely and in good faith and for some
Oh, that's
good reason.
different.
You don't even want to
Well, I don't know.
bother
whether-
yourself with it.
My problem is with that, and for some good reason. In other words, I understand if it's to get, you know, to try and, if the purpose is to try and deprive the other person of custody, I mean, that comes very close to, you know, a sort of pre-kidnapping kind of thing. But it's also whether, you know, I'm just saying this, I don't intend to move. That's different. But it does concern me that the court is saying, well, this isn't a good move.
well, the basis for making that determination, Your Honor, is to evaluate. And it has to be done in a situation where the court is going to, unfortunately, the court is the last resort. And
No,
the
you can
parties-
evaluate the impact on the children, and you can say to the mother, you're free to go. You're free to go, but the consequence is going to be that, the custody devolves to the spouse, to the remaining spouse, for example.
Your Honor, the only response I would have is that if somebody's seeking to move, they articulate the motives, the reason for their move, which is what happened in this case. And the plaintiff articulated her motives for wanting to move. The mother indicated that these are the reasons why. I want to move because of the economic benefit, and I want to move because of the fact that it would be detrimental if I were separated from my husband.
I tend to agree with you that the motive has to be looked at in light of the best interests of the children.
No question of that.
Yeah, I mean,
No
for
question of
example,
that.
if one of the children or both the children were, say, given full scholarships to Phillips Exeter Academy, but the proviso was they can't live here, and coincidentally she could get a job in the immediate area of Exeter, that would be a motive definitely playing complementarily into the best interests.
No question that that's a valid inquiry. No question.
Have you looked at the American Law Institute's latest stuff on family law dissolution and all that?
I have, Your Honor. I think it may be referenced as well in one of the briefs of the amici.
Okay. All right.
The issue here is, and there's in the U.S. there's the divergent approaches on how to deal with this, and there is no, at least from what I've been able to discern, any uniformity in the approaches that have thus far been taken. It's a relatively new issue, and there is not a great deal of prior precedent. However, what we do have is we have a legislative mandate in this case as to what governs modification actions and the approach that needs to be taken.
It seems to me that, again, regardless of what door one goes in through, that the legislature has spoken again and again and again and again and said at the core of all of these decisions is what is in the best interest of the children. And so regardless of how you construct it, that's the bottom line inquiry.
And I would agree with that, Your Honor, because even under a 208 Section 30 analysis, the point of departure is for good cause, and for good cause has been defined by the courts to mean the best interests of the children. So that's where the focus ought to lie. And in this particular case, Your Honor, I would respectfully submit that's exactly what the trial court did. She looked to the best interests of the children and determined that it was in their best interests that joint custody be maintained and that the removal not take place.
Thank you, Mr. Will.
Thank you, Your Honor.